is converted into Section 4 because there is a demand, but the ingredients of 3 of Dowry Prohibition Act is not satisfied. And so far as sentence is concerned, you have to go back because the necessary exercise has not been done by the appellate authority. The informant as well as the accused, they have to appear before the learned appellate court on 18/3/2024. It will be uploaded by the evening. You can have it.
For penalties for item 3, CRMP is 694 of 2011 along with item 4 to 6.
Yes. Okay. Give me the judgments.
Judgment I have given bunch of judgments.
All these matters were sent to Jhalsa for mediation.
Yes, all the.
Where is the mediation report? All these matters have been compromised.
Yes, now, since one of the matter, referring to one of the cases, the matter was sent to Jhalsa, there are a number of cases.
That's
Of the number of cases, we have already cited the number of cases, they are both party compromised, and the compromise petition.
In page number 13,
Just. These are the terms of settlement.
Yes.
page number 13.
So let us see which one is relating to which criminal CRMP.
First of all, 1.4 CRMP number 694 of 2011.
Just a minute. 1 point,
1.4, page number 13.
page number 13,
1.4,
1.4. This is relating to
694 of 2011.
CRMP number 694
4 of 2011.
2011. Then this one,
54 of 2012. Pawan Kejriwal and others.
yeah. This is CRMP number.
So, opinion of
54 of 2012.
Okay, 54 is given. Okay, case number is given.
yes, case numbers are
Yes,
given there.
yes,
Case
all
numbers are
these-
given.
1, 4,
These are the 4 cases.
yes, 4, 5, 6, and the last one, 1.4, 1.5, 1.7, and 1.8.
Okay. Now, as per the terms of settlement, what is the stage? What are the corresponding stage of this?
Matter is at the stage of framing of charge. We are framing the matter over the framing of charge.
Okay, at the stage of framing of charge.
Yes.
All the cases.
All the cases.
All the cases. These are arising out of 4 different criminal cases.
No,
Same cases.
these are number.
These CRMP are arising out of different criminal cases.
No,
FIR numbers.
Yes. FIR number Kotwali PS case number 344 of 2011.
344 of 2011 is relating to
Relating to all this.
all these 4 CRMP is arising out of same criminal case.
Yes, ma'am.
Give me all the records.
Yes, ma'am. Three 44 of 2011.
Same FIR.
Same FIR.
All the cases.
All these cases. All these cases. Few are named and few were surfaced later on after the investigation.
And all the petitioners are the accused persons in the case?
Few are named and few have been
Few are
settled.
unnamed.
Yes. Ashok Kejriwal, he is named. Prabhat Pandey, he is named. Jitendra Kumar, he is named. Pawan Kejriwal, he later on settled. And even Uday Shankar Ojha, me not for him, I have also filed the IE that he has died.
These are essentially within the private dispute
Yes.
between the parties.
Private dispute, it's a civil nature. Now, in terms of this, we have already compromised with the issues. Rather, OP number 2 also had filed a CRMP. Thereafter, this coordinate bench of this honorable court has already passed on that. So,
Yes, sir.
He had also filed a CRMP for what
Yes.
purpose?
CRMP for quashing of the entire question on the basis of this conciliation, the Jhalsa, before the Jhalsa settlement, which
He
has
also filed a complaint case.
Yes,
Lajpat Bhajan ka.
he is the OP number 2 in all the matters. We have already signed this.
So this particular complaint case, which has been ultimately settled,
Yes.
is a part of the compromise, joint compromise.
Yes.
Let's have a look at it. This number must be mentioned. This is complaint case number 1467. Complaint case number 1467. Yes.
1467, 1.2.
1.2. There was a protest petition also.
Yes.
Okay,
Yes.
thank you. Learned counsel for the parties are present. State is absent. Do you have any objection to the joint compromise? Do you have any objection to the joint compromise between the parties? All these cases arise out of FIR number 344 of 2011, Police Station Kotwali, Sukhdev Nagar, Ranchi, GR number 1921 of 2011,
Yes.
for alleged offence under section 384, 387, 465, 466 and 468 of there are more sections. 384, just take it. 384, 387, 388, 389, 465, 467, 468, 471, 218, 219, 220, 506 within bracket 2, 193, 195, 196, 199, 209 and 211 of the Indian Penal Code. The parties were in litigating terms and there were case and counter case between the parties. The matter was sent for mediation by an order of this court, and the mediation report has come indicating that they have settled the matter in terms thereof and different cases were to be withdrawn. Pursuant thereto, in all the cases, joint compromise petition has been filed, and one joint compromise petition being IA number 1650 of 2024 in CRMP number 1272 of 2011 has been presented before this court today, which is taken on record. The other interlocutory applications in the connected cases are IA number. Tell it from the list. IA number 11580 of 2023 in CRMP number 694 of 2011. IA number 11579 of 2023 in CRMP number 815 of 2011, and IA number 11586 of 2023 in CRMP number 54 of 2012.
There is one another.
Why a petition for deleting the party?
Yes, because Uday Shankar Ojha now
One IA number 11643 of 2023 has been filed in CRMP number 54 of 2012 for deleting the name of Shri Uday Shankar Ojha by stating that he has expired during the pendency of this case. The learned counsel for the parties have submitted that the criminal case is at the stage of framing of charge.
we are arguing over the discharge petition.
Discharge, okay. The criminal case before the learned court below is at the stage of discharge, and in the meantime, the parties have entered into joint compromise, and joint compromise petitions have been filed in the present case. They have submitted that the dispute arising out of the criminal case is essentially in the realm of private dispute between the parties, and considering the fact that the parties have settled their scores, no useful purpose will be served by further proceedings in the criminal case, and appropriate order be passed under section 482 of CRPC, so that the entire criminal proceedings arising out of the aforesaid FIR is quashed by this court. Give me just one, which would be the best?
Narinder Singh, even Gyan Singh judgment has also been incorporated.
Where is Gyan Singh judgment?
Gyan Singh judgment is incorporated in Narinder Singh judgment.
Okay, let us
It is
see.
located with 307.
Just page number?
Page number 19 to 30.
The learned councils have jointly referred to the judgment passed by the Honorable Supreme Court in the case of Narinder Singh versus State of Punjab, reported in 2014 within bracket 3 bracket close Eastern Criminal Cases 19 within bracket SC. Paragraph number?
31 and 35.
Para number 31
And 35.
and 34.
35.
Okay. That is no problem.
Para number 31, 34 and 35.
35.
The learned councils have submitted that the ends of justice will be served, and parties have voluntarily and have voluntarily entered into joint compromise and therefore appropriate orders be passed. That should be sufficient. The Learned Counsel for the state has no objection to the joint compromise between the petitioners and the opposite party number 2. In all the cases, opposite party is the same.
Yes, opposite party.
In all the cases, the opposite party number 2 is the informant of the case. After hearing the Learned Counsel for the parties and considering the nature of allegations and counter allegations involved in the the Learned Counsel has also submitted that the opposite party number 2 has also acted upon the joint compromise entered into between the parties and consequently has
CRMP number 4022.
And consequently CRMP number 4022 of 2022 filed by the present opposite party number 2 has been quashed and set aside, has been allowed
Yes.
by this court, and the order dated 26/3/2018 passed by Learned SDJM Ranchi in connection with complaint case number 1467 of 2012 has been quashed and set aside. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the parties have settled their scores and the parties are no longer willing to proceed with the criminal case involved in the present case, and have entered into joint compromise it appears that the dispute between the parties is in the realm of private dispute and has a civil flavor, and this court also finds that there is no legal impediment in quashing the entire criminal proceedings once both the parties have entered into joint compromise. There is no likelihood of any conviction in the criminal case as they have already entered into joint compromise. Because of the compromise between the parties, the possibility of conviction is remote and bleak, and continuation of criminal case would put the accused persons to would be of no use. And the interest of justice, and for the interest of justice and in exercise of power under section 482 of CRPC, the entire criminal proceedings arising out of Kotwali Police Station case number 344 of 2011 corresponding to GR number 1921 of 2011 is hereby quashed and set aside. I'll just put one paragraph of one of the judgments. All the IA for joint compromise are allowed. Should I put the terms of the compromise in the order?
Not required.
Not required. So far as IA for deleting the name of the party is concerned, that is allowed. That is also allowed. Other IA is closed.
Close.
Let this order be communicated to the non-approved.
Deeply.
All disposed.
Item 7, WPC 7479 of 2013. Item 8, WPS 5671 of 2014.
I should have furnished the list of dates. Matter relates to punishment. Punishment, twofold punishment. One was censure and second was forfeiture of any increments and non-cumulative effect. But the petitioner was a member of
Minor punishment?
Yes, punishment.
Minor punishment?
No, minor punishment, yes. The petitioner was a member of Jharkhand Academic Service, Jharkhand Administrative Service, and he was appointed in the year 2000. In the year 2006-7, while his posting at Bagodar as Block Development Officer, he was put under suspension on the charge that he was found to be involved in the irregularities in execution of Deen Dayal Awas Yojana. This was the allegation. Subsequently, an FIR was lodged and he was subsequently added, his name was added during the course of investigation and he was put to trial. In the year 2007, the aforesaid suspension order by which the petitioner was suspended, it was challenged before this honorable court and the same was quashed. Thereafter, the petitioner was served with Prapatrika. 5 court charges were there, but all related to the same transaction while his tenure as Block Development Officer, Bagodar. And the punishment was also inflicted upon him, which was subsequently also quashed, as the same was a decision to initiate a departmental proceeding or initiated so was reply from the now presenting officer report. This is very important. The presenting officer submitted his report, whereby he has stated that the petitioner is not involved and everything which he produced as an evidence, that same is true and genuine. So everything he favored the petitioner in totality, my lord. Thereafter, my lord, decision.
Inquiry report was in your favor or against?
Presenting officer report.
Presenting officer's report is not there.
Inquiry officer report was not served to me. Therefore, I challenged the same before this honorable court, and this was quashed again. Subsequently, also quashed because of non-service of inquiry report.
So
and
thereafter, the second show cause everything was
Second
done,
show
and
cause given.
ultimately, so now there is no procedural irregularity.
No,
Yes.
no procedural irregularity. Now, if my lord comes to the charge, my lord, charge memo annexure 1 for me.
What is your case? What is your
Yes,
point?
yes,
So far as procedural irregularity is there, it is no more there.
I am not going on that.
Right.
I am coming on facts.
So what is your point?
Annexure 1 for
Your
me.
point, please. First, you formulate your point.
First, 3 points are there. First is that it is a case of complete no evidence. As on the same set of charges, the criminal proceeding was also initiated and I have been honorably acquitted in that criminal proceeding, which I have annexed in the supplementary affidavit. Second, co-delinquent, that is a Nazir, he was also held guilty along with me in the same charge sheet which was served to me, and he has been totally exonerated, and I have been punished. So there is a violation of doctrine of parity among co-delinquents, my lord.
So he had the same responsibility as yours?
Yes, he was the ultimate, my lord. He has the function to disperse the check and everything. He was the main. If it is assumed that something has happened, he was the main at fault, my lord. But he has been exonerated and I have been punished.
Where is his order of exoneration?
My lord, his order of exoneration is not, we have stated in our writ
Please.
petition, my lord.
This, it can't be like this, right?
They are not
You are
denied.
we are not, we do not know.
They
It
have
was
not
for
denied.
you to annex, we do not know.
And the third point is
Nazir,
Nazir. And
the
the
checks
third
are signed by whom?
चेक, मतलब द पर्सन हु एलेस्ट की मेरा अगेंस्ट चेक आया था, वो पर्सन खुद एफिडेविट दिया जो हम रिट पिटीशन में लगाया है, एंड ही सेज कि मेरे कोई इरेगुलरिटी नहीं
He
हुआ.
was examined in the
No.
in the inquiry.
No, my lord, he has given an affidavit which I have annexed in annexure
Then
7.
he has given it to you.
It has come in during the course of investigation, my lord.
We do not know.
It
You
was
will.
pro-
You see, this is something I just can't understand. In a departmental proceeding,
Yes.
you will annex an affidavit which is not a part of the records in the departmental
But
proceeding.
inquiry report has not been served to me along the second.
We do not know. All those procedure is over.
So that thing I am not taking the plea, but this person Nazir, the entire allegation rests upon one सुरेश भुइया. सुरेश भुइया को चेक दिया गया था और सुरेश भुइया का वहाँ थे नहीं, फिर भी उनके नाम से चेक कटा. अब सुरेश भुइया बोल रहे हैं कि मेरे नाम से जो भी चेक कटा वो हमको पैसा मिल चुका है. मेरा
Did he depose before the disciplinary authority?
that they can state.
No, no. You can also state you participated in the proceedings.
But the report has not been served to me, my lord.
No, we do not know. You say that there is no violation of natural justice. So report has not been served to me means what? You were given the second show cause.
Second so was given.
And you
And-
see, I have seen the records, and so far as Suresh Bhuiya is concerned,
Yes.
the allegation is that you did not follow the procedure. It was a bearer check. You were not supposed to give a bearer check. All the checks were to be paid, account paying.
Yes.
And he
sir.
withdrew that money.
But
This is the irregularity.
On the same set of
This
charges.
is irregular. This is absolutely irregular.
But that has to be proved, my lord. That has been, why not they have not proved the same before the
That
trial
is-
court, my lord. Trial court has already acquitted me, my lord. That report is that.
That's it. That's it. Trial court
Let
has
me say
acquitted you.
one more point, my lord. Delay in departmental proceeding, my lord. In conclusion of this departmental proceeding, charge is of 2006-7 and this punishment in 2014. So this is completely violative of the Honorable Apex Court judgment in two cases, Bani Singh with the state of MP, and
2000?
this is judgment I have brought, my lord, to use this judgment.
The punishment is of?
2006-7, this allegation is around.
Okay. And
of
punishment is of?
Punishment in 2014. Final punishment order which has been challenged in this petition.
No. And when did you challenge it?
2007 itself.
7 itself, my lord. Since 7 I am litigating before this honorable court, and 3 times, this is the third petition which the petition has put. This judgment on doctrine of parity, Rajendra Yadav versus State of MP. This is upon delay in departmental proceeding. And this is case of no evidence.
Here's the paragraph.
Para I have mentioned on the top. Para 12 of this case, Rajendra Yadav judgment. Second is
Just a moment. Rajendra Yadav.
Yes, para 12.
This is on parity.
Parity, doctrine of parity, para 12.
Read it, please.
Yes. The doctrine of equality applies to all those who are equally placed, even among persons who are found guilty. The persons who have been found guilty can also claim equality of treatment if they can establish discrimination while imposing punishment when all of them are involved in the same incident. Parity among co-delinquents has also to be maintained when punishment is being imposed. Punishment should not be disproportionate while comparing the involvement of co-delinquents who are parties to the same transaction or incident. The disciplinary authority cannot impose punishment which is disproportionate, that is lesser punishment for serious offences and stringent punishment for lesser offences.
What was your designation?
Block Development Officer.
And you are comparing yourself with?
Najir. Second,
The punishment order of Nazir is not on record.
no. But we have stated in our pleadings that he has been exonerated and we have been punished. That has not been denied by them. Second judgment, WPS 1095 of 2019.
Where is the charge sheet? Where is the charge sheet?
Yes, annexure 1. Page 22. In very last line, my lord reads, my lord, इस प्रकार प्रश्नगत मामले आपके द्वारा योजना के कार्यान्वयन में सरकारी नियमों का पालन नहीं करना, अनुचित लाभ लेने के लिए फर्जी भुगतान कराया गया, जिसके लिए नाजिर के साथ आप भी दोषी हैं. And on the same set of charges, I have been honorably acquitted by the Ladakh Trial Court. my lord.
This is the charge sheet issued to you.
Yes, Prapadraka.
But where is the charge sheet issued to Nazir? That is also not on record.
That is not. But in my charge sheet itself, it has been stated that Najir will equally involved.
We cannot treat your charge sheet as his charge sheet.
No, that is true. Then my ladyship comes to the impugn order.
Just a
for-
moment. Okay, this is one judgment.
Yes. Second one is,
This is on parity. Second one is para 12.
yes, para 12,
This is
BC Chaturvedi.
which paragraph are you referring to?
12,
Para 12.
yes.
What is it?
Judicial review is not an appeal from a decision, but a review of the matter in which the decision is made. Power of judicial review is made to ensure that the individual receives fair treatment and not to ensure that the conclusion which the authority reaches is necessarily correct in the eyes of court. When an inquiry is conducted on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rules of natural justice are complied with. Whether the finding or conclusion are based on some evidence, the authority entrusted with the power to hold inquiry has jurisdiction, power and authority to reach to a finding of fact or conclusion. But that finding must be based on some evidence. Neither the technical rule of evidence act nor the proof of fact or evidence as specified therein apply to discipline proceeding. So this is on.
So you say it is not based on any evidence because
Yes.
you have been acquitted in the criminal case.
And not even proved in the because the impugn order at which may be seen, there is no iota of evidence which they speak.
Where is the inquiry report?
Inquiry report I have not received, ma'am.
You have not received
No.
or you have not annexed.
I have not been served ever, ma'am.
From where do you say that it was not? So
On-
how did you respond to your second show cause notice?
Second show cause only was given. This notice has come before me. Inquiry report is
Second
different.
show cause is you see after second show cause is issued accompanied with the inquiry report.
If my lord tells us the second show cause notice, it is not mentioned the inquiry report has been served to me. And I have,
Did you in your second show cause reply did you say that the inquiry report has not been served on you? That is
My
not your
second-
case.
my second show cause reply may kindly be seen for a moment. Only 4 paragraphs reply is there, my lord.
We do not know. You say that you are not concerned with the procedural irregularity in as much as no natural justice is involved in the present
Yes, I
case.
am not going on that. I am still on that. I am not.
Then why are you arguing that second show cause was not
Because my
issued? That's a
leadership-
part of natural
My
justice
leadership
only.
asked whether I have been served with the inquiry report, so I only replied it has not been served to me. That's it. And third judgment,
No, just a moment. This your statement in para 16 is contradictory to your statement in para 19. In para 16 you say the inquiry report was not served and without giving second show cause, and then you say that you filed a reply also to the second show cause.
second show cause and inquiry reports are different things.
Second show cause is issued accompanied with the inquiry.
Not
report.
always, my lord. Not
Not
always.
always means
Not always they serve the second inquiry report.
Second
with the
show
inquiry.
cause comes only when the disciplinary proceedings has to take a call.
Yes, take a call on the proposed punishment which he thinks he
Naturally,
is
because that is
But-
always based on the
But
inquiry report.
in this case itself, my lord, it was not served in the previous round, therefore it was quashed, my lord, the previous punishment order. second round of litigation was based upon the inquiry report itself. It was not served and therefore it was quashed.
And
And after that, my lord, only a mere formality of serving a second supers, seeking my reply and finding the final order. That is annexure 14 impugned in this petition. And no points of mine have been considered which I have raised in my second super's reply. None of them have been examined by the disciplinary authority itself. If my lord produces the impugned order for a moment. Annexure 12, page 43. Only charges have been quoted up to point number 5.
the order of this court has been complied, previous order, isn't it?
Yes, they have served the second supers, and but the reply has to be seen. At least why they sought this reply. Then if they did not want to say, they could have directly passed the punishment order. But if I have replied something, that should come in this order. Yes, this point has been taken and this thing has not been addressed. Directly confirming the same punishment order, my lord. इसमें बोले 3 और 4 प्रूफ हुआ, आपको फिर से यही सजा देते हैं. 4 नंबर 3 and 4 are proved, and that is upon Suresh Bhuiya.
You just have a look at it, page number 40.
40. Yes.
जैसा कि संचालन पदाधिकारी के निष्कर्ष में लिखी बातों से स्पष्ट होता है. How do you say this?
प्रस्तोता पदाधिकारी.
No,
Presenting.
संचालन पदाधिकारी के निष्कर्ष से लिखी बातों से स्पष्ट होता है. Right? You are referring to the
Page
inquiry.
40.
Page 40. Is it your reply? Satya Prakash is your name?
हाँ, सत्य प्रकाश.
You just see page number 40.
Yes.
You are referring to the inquiry report only. And then you say that you don't have a copy of the inquiry report. How is it possible?
That's why I am not placing this.
So therefore don't say that you have not been served with a copy of the inquiry
I have
report.
been served with the.
Then how do you respond? How do you refer to the inquiry report to make a statement? नीचे से 4th line.
हाँ. जैसा कि संचालक पदाधिकारी निष्कर्ष में लिखी बातों से स्पष्ट होता है,
हाँ.
प्रस्तोता पदाधिकारी निष्कर्ष के प्रति संलग्न.
226 में झूठ बोल के नहीं निकल सकते.
झूठ नहीं, हम
और मेरे सामने तो बिल्कुल नहीं.
हम तो उस पर रिलाई ही नहीं कर रहे हैं, my lord.
Rely नहीं कर रहे. But when I am asking you time and again, where is the inquiry report? You have not annexed a copy of the inquiry report, and you say that you were never served with it. In your second show cause, you are referring to the inquiry report. So there is material suppression from your side also. You want a disciplinary proceedings to be decided without going through the inquiry report, and you say that it was never served on you. When you read the brief, no, you should read it line by line, because I read it line by line. Anyways, we shall see. Okay.
Now the third judgment on the delay, my lord.
Third judgment on delay.
Yes.
This one.
Delay in departmental proceeding. Para number 10. Among
WPS 1095.
Yes. State of Madhya Pradesh versus Bani Singh has been referred to, my lord.
Para number 9.
Para 10.
Para 10.
1990 supplementary SCC 738. The appeal against the order dated this and this has been filed on the ground that the tribunal should not have
No,
filed.
this one. WPS 1095.
Yes.
Para number 10.
Para 10.
The Honorable Apex Court.
Yes.
Okay.
The Honorable Apex Court in the case of the state of Madhya Pradesh versus Bani Singh and another.
Hmm.
The appeal against the order dated so and so has been filed on the ground that the tribunal should not have caused the proceeding value on the ground of delay and laches and should have allowed the inquiry to go on to decide the matter on the merits. We are unable to agree with the contention of the learned counsel, the irregularity which were the subject matter of the inquiry is said to
That's
have
all? That's all?
Delay.
All 3 points? We have seen.
and the honorable acquittal by the learned trial court on the same set of charges. interested in grab of this punishment order which prolonged for 7 to 8 years. I have been denied promotion several times, my lord. I have now become junior to my junior also, my lord. So how many punishment on the same fact which is not at all proved by the
You have made payment through bearer check. That is an irregularity.
but that
We'll see
did
that.
not cause any because it is the person Suresh
Therefore,
Bhaiya has-
otherwise you would have been dismissed.
the person
That's why
should-
a minor punishment.
My lord, then they would have to produce that thing before the learned trial court also, my lord. Ki
It's
no,
there.
it is not in the trial court.
Okay, all right.
No evidence.
Listen to
That's-
the order. I've heard you. Listen to it. Yes.
Your Ladyship, as far as the criminal case is concerned, it was for fraud, and the petitioner has been punished for negligence in his duty. So those are two separate things. As far as the service of the inquiry report is concerned, in paragraph 40, we have specifically stated that it was supplied to him along with the second show cause.
In
So,
para 14.
Paragraph 40 of the contract.
That's it.
And he cannot dispute, he has never disputed that it's his signature at the bottom of the register. He has been punished for not verifying the records and just putting his signature.
Not verifying the record and putting his signature in. It was a bearer check.
Yes, ma'am.
WPS number 5671 of 2014 heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was appointed on the post of deputy collector by BPSC Bihar and was allocated Jharkhand cadre after bifurcation in the year 2000. The petitioner was put under suspension on 27/12/2006 on the charge that he was found to be involved in irregularities in execution of Deen Dayal Awas Yojana. An FIR was lodged on 11/7/2007 for alleged offence under section 419, 420, 467, 468, 471 of IPC. The learned counsel submits that during the pendency of this case, the petitioner has been acquitted in the criminal case. He has submitted that a charge sheet was issued to the petitioner on 14/10/2007 in Prapatra K relating to 5-fold charges which were all correlated with each other. And the order of suspension was quashed by this court in writ petition as back as on 12/12/2007. However, a decision was taken to initiate the departmental proceeding against the petitioner. The inquiry officer submitted his report, and the disciplinary authority by order dated 1/10/2012 inflicted punishment of censure and forfeiture of 3 increments, sans non-cumulative effect. The learned counsel submits that the order of punishment is a minor punishment. However, the petitioner filed a writ petition before this court, being WPS number 478 of 2013, and the writ petition was allowed, and the impugned order of punishment was quashed on the ground of procedural irregularity, and the matter was remitted back to the respondents to pass fresh order after affording proper opportunity to the petitioner. Consequently, the petitioner was served with second show cause, to which he replied on 26/5/2014, and thereafter the impugned order of punishment dated 8/9/2014 has been passed with the same punishment, and consequently the present writ petition has been filed. The learned counsel has submitted that so far as procedural irregularity is concerned, he is not pressing his case on such point. During the course of argument, he has raised 3 points. A, it's a case of no evidence against the petitioner inasmuch as the petitioner has been acquitted in the criminal case. B, the co-delinquent who was Nazir has not been given any punishment and has been exonerated, and the petitioner stands on the same footing. And C, the departmental proceeding was sought to be initiated way back in the year 2006, and the order of punishment has ultimately been passed in the year 2014, and therefore there has been inordinate delay, and consequently the entire departmental proceeding, including the order of punishment, is not sustainable in the eyes of law. However, during the course of arguments, the learned counsel has submitted that the inquiry report in the present case is not on record. He has submitted that the same was never served on him. Further, he has also submitted that the charge sheet issued to Nazir as well as the order of punishment of Nazir is also not on record.
It was not punished, so order of punishment is
Or the order exonerating Nazir is also not on record. The learned counsel has relied upon following 3 judgments. A, judgment passed by the Honorable Supreme Court in the case of Rajendra Yadav versus State of MP. Paragraph 12. They reported in what is the Supreme citation? 2013 2 Supreme.
yes, 2013 3 SCC 73.
Reported in 2013 volume 3 SCC
73.
73. Paragraph would be the same.
Yes, para 12.
Paragraph 12, which is quoted as under. he submits that the doctrine of equality applies when when two equally placed persons are subjected to departmental proceeding and one is acquitted, where one is exonerated and punishment is imposed on the other. B. Judgment passed by Honorable Supreme Court in the case of B.C. Chaturvedi versus Union of India,
1995 6 SCC 749.
reported in 1995, volume 6 SCC 749. He has referred to paragraph 12 thereof, which is quoted as under. इसका जो quotation लेके देख के ये सुप्रीम टुडे का है, you have to accordingly change the paragraph number, and has submitted that that in a case where the findings are based on no evidence, appropriate order is required to be passed by the writ court. And he has again referred to the acquittal order passed in the criminal case. C.
State of Madhya Pradesh versus Bani Singh and another reported in 1998.
That is, he has referred to order dated 28/11/2019, passed in WPS number 1095 of 2019, and has submitted that in the state judgment, the judgment passed by the Honorable Supreme Court in the case of State of Madhya Pradesh versus Bani Singh and another has been taken into consideration in para 10. The judgment of the Supreme Court is reported in 1990 within brackets something bracket close SCC 738, and has submitted that in case of inordinate delay in departmental proceedings, the same is required to be quashed. The learned counsel appearing on behalf of the respondents, on the other hand, while opposing the prayer, has submitted that there has been no violation of principles of natural justice. In paragraph 40 of the counter affidavit, it has been stated that the inquiry report was served upon the petitioner along with the second show cause. The learned counsel has also referred to the show cause reply filed by the petitioner to submit that the report of the inquiry officer has been referred to in the show cause reply also. Is that correct?
Yes, sir.
The learned counsel has further submitted that the criminal case and the departmental proceeding in the present matter are on different footing altogether. The petitioner has been punished on account of negligence in doing his work, and he had put his signature in the register without verifying the records. He has also made payment by issuing check, although which was a bureau check, and although as per the circulars, the amount to the beneficiary has to be credited in the bank account. This is not a part of any record, this affidavit of the beneficiary.
This is in my petition.
In response, the learned counsel for the petitioner has referred to Annexure 7 to the writ petition and has submitted that the beneficiary, namely Suresh Bhuiya, has stated on affidavit before notary as annexed with Annexure 7 of the writ petition, stating that the amount was taken by him. However, the learned counsel has fairly submitted upon a query of this court that Annexure 7 was never a part of the documents or defense produced by the petitioner before the disciplinary proceedings, and the said document has been produced before this court for the first time. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the following charges were leveled against the petitioner. Page 9 of the counter affidavit. It is summarized. Which was in Prapatra Ka, dated 14/10/2007.
After the years 14/10/2007.
14/10/2007 within bracket Annexure 1. It appears that the petitioner was initially put under suspension on 27/12/2006. However, the order of suspension was set aside by this court. In WPS number 4229 of 2007. The respondents proceeded with the departmental proceedings, and a decision to that effect was taken on 11/4/2008. The inquiry officer had submitted his report and the disciplinary authority passed an order of punishment dated 1/10/2012 of censure and forfeiture of 3 increments sans non-cumulative effect. The same was challenged by the petitioner before this court in WPS number 478 of 2013, and the said writ petition was and the order of punishment dated 1/10/2012 was quashed by this court by judgment dated 9/12/2013, and the matter was remitted to the disciplinary authority for passing a fresh order after affording an opportunity to the petitioner for making his representation. The findings of the learned writ court is quoted as under paragraph 8 and 9 at page number 38 of the writ petition. Thereafter, second show cause notice was issued to the petitioner, to which he responded as contained in Annexure 11. From the perusal of Annexure 11, it has been, this court finds that the petitioner has also referred to the inquiry report, to the contents of the inquiry report, and ultimately the impugned order dated 8 September 2014 has been passed maintaining the same minor punishment which was imposed earlier, that is censure and stoppage of 3 increments with non-cumulative effect. Upon perusal of the impugned order, this court finds that a finding has been recorded that the petitioner has violated the instructions contained in letter number 9168 dated 12/10/2006 and letter number 9522 dated 20/10/2006 issued by the Rural Development Department, wherein there was a clear stipulation that the amount is to be remitted to the bank account of the beneficiaries and no check or cash could have been paid. The petitioner, it has also been mentioned therein in the impugned order that that there was irregularity in making payment to Suresh Bhuiya, making payment in the name of Suresh Bhuiya. This court also finds that the petitioner had responded to the Annexure 5 is your response to show cause?
Yes, Annexure 5 is no reply, so far reply.
The petitioner had filed a show cause reply earlier as contained in Annexure 5, wherein he has stated that the amount was taken by Suresh Bhuiya, but has also submitted that a large number of payments were being made through without account paid check, and which was being done earlier also. However, from the perusal of the order of punishment, it appears that the petitioner had violated the instructions issued by the Rural Development Department. No such argument has been advanced by the petitioner that his acts were not contrary to the aforesaid circulars issued by the Rural Development Department. This court finds that the petitioner has been exonerated, was that in the criminal case wherein the petitioner has been acquitted, no prosecution evidence was produced for the alleged offence under section 419, 420, 467, 468, 471 and 409 of IPC. Apparently, the criminal case was on account of the ingredients in connection with the aforesaid sections. and had nothing to do with the negligence committed by the petitioner in the matter of disbursement of the amount to the beneficiaries and violation of the circulars issued by the department relating to the mode and manner of payment. This court is of the considered view that the affidavit filed by the petitioner for the first time as contained in Annexure 7 cannot be taken into account. No fresh document.
This will come into error because this has been served.
Served means?
By the Annexure 6, it has been this affidavit has been given to the DC grading. By the Annexure 6, madam.
Served means served to whom? It was a part of the inquiry report.
He has given and taken this plea in the entire supposed replies, my lord.
We do not know. I asked you a specific question. You said that this has been incorporated for the first time in the writ petition.
This document has come ultimately, but the fact is there in all this.
Fact must be there, but this document has come up for the first time.
Fact is there.
A new document which has been annexed by the petitioner in the writ petition for the first time as contained in Annexure 7 cannot be taken into consideration, and otherwise also the violation of the circulars by the Rural Development Department has nothing to do with Annexure 7 of the writ petition. In view of the aforesaid facts, this court is of the considered view that the argument of the petitioner that the present case is a case of no evidence on the basis of his acquittal in the criminal case has no merit at all. The criminal case and the departmental proceedings were on different set of allegations. Inasmuch as the departmental proceeding, the petitioner has been held guilty in the departmental proceeding on account of negligence in duty and non-compliance of the directions/circulars or instructions issued by the state government, and the criminal case was, and the petitioner was acquitted in the criminal case on account of the fact that no witnesses had appeared before the criminal case. The allegations in the criminal case were for the purposes of trial of the petitioner vis-a-vis the ingredient of the offences mentioned above. So far as the claim of parity is concerned, the petitioner has neither annexed the copy of the charge memo issued to Nazir nor the order by which Nazir has been exonerated has been brought on record by the petitioner. Moreover, the impugned order reflects clear case of negligence and irregularity committed by the petitioner, and accordingly the plea of parity of the petitioner is also not sustainable in the eyes of law. So far as the argument of the petitioner that there has been inordinate delay in concluding the departmental proceeding is concerned, this court finds that there has been several rounds of litigations, and ultimately the order was passed by this court in WPS number 478 of 2013 on 9/12/2013, wherein the earlier order of punishment dated 1/10/2012 was quashed and the matter was remitted to the disciplinary authority for passing a fresh order after affording opportunity to the petitioner to make his representation. And immediately thereafter, the impugned order was passed on 8 September 2014. Since the impugned order has been passed in compliance of the order passed by this court, it cannot be said that there has been delay in the matter, Moreover, in the judgment passed by the Honorable Supreme Court in the case of State of Madhya Pradesh versus Bani Singh, reported in 1990, Supply SSC 738, and referred to in WPS number 1095 of 2019 in paragraph 10, clearly indicates that the matter remained pending and no final order was passed in the departmental proceedings. And in such circumstances, the Honorable Supreme Court held that the departmental proceedings cannot go on for an indefinite period. And there was no satisfactory explanation for the inordinate delay in issuing the charge memo. And the Honorable Supreme Court was of the view that it will be unfair to permit the departmental inquiry to proceed at that stage. In the present case, the departmental proceeding has been concluded and the final order of punishment has been passed. That's all. As a cumulative effect of the aforesaid findings, there being no merit in the present case, which is accordingly dismissed. There will be numerous corrections. You may not get the exact, but these are the findings. I will change the sequence of paragraphs also. It's an open court discussion. Therefore, there has to be errors in dictating the order. I'm saying so because these are all recorded proceedings. So I have to be careful, and you also have to be careful.
Matter 9, WPS 4956 of 2015.
Yes, petitioner.
In the last occasion, I filed the rejoinder. I have been directed to file rejoinder and list of date. I already filed that.
Where is your IA filed before the LPA court?
Yes, ma'am.
I want to see the IA.
Yes. I filed by way of supplementary affidavit dated 21st 9, 2023. In
21st
that
9.
supplementary affidavit, my lord.
Where is your supplementary affidavit? You have annexed a copy of the IA?
Yes, ma'am. In that supplementary affidavit, I have annexed the IA 2554 of 2023 in LP, which have been filed.
What is the date of filing?
It is supplementary affidavit filed. It is not the other case.
No, this is supplementary affidavit. I want to see the IA filed in the
In
LPA
that
court.
supplementary affidavit, annex
Okay.
the IA petition.
Fair enough.
Yes.
All right. Who was the inquiry officer?
Madam,
Who was the inquiry officer?
inquiry officer.
So now your case has to be considered on the account of violation of principles of natural justice. Right? That is your case? Tell us. Arjun?
My prayer is my lord, that was not considered in the department proceeding.
In the initial writ petition, since no plea was raised, therefore it was not considered. In the LPA, you file an amendment petition to the writ petition,
Yes.
and then the matter has been remanded for consideration on the point of natural justice.
Natural.
Is there any other point you want to argue apart from natural justice? Because I have to take care of that.
My lord.
Do you want to? You just tell us
My lord, after
very, very clearly. Is there any other point you want to argue apart from natural justice?
no, madam, all these things I have I filed before the memo of appeal, and also under in departmental inquiry, witnesses, I have been debarred.
Mr. Counsel, please hold on. I'm just asking you a specific query that your case is wholly based on violation of principles of natural justice, correct or not correct?
Yes, ma'am.
Let me just record it. Who was the inquiry officer? And where is the inquiry report? Where is the inquiry report?
We have annexed it in a counter affidavit, Your Lordship, at annexure M, page number 72.
Page number?
Page number 72 of a supplementary counter affidavit. Annexure M.
72. Yes, now you argue your case. Yes.
In this case, the prisoner praying for passing of my lord 5/2/2015 passed by the superintendent of police, and along with
5/2/2015.
15,
Okay.
along with the appellate order dated 25th January 2016. Annexure 11, my lord, appellate order under election.
Is annexure 11 and
Election.
original order is?
Original order is my lord, original order is annexure 11, my lord, page 43.
5/2/2015.
5/2/2015.
Is annexure
11.
11 and appellate order?
And appellate order, my lord, annexure, my lord, annexure 13, page 54 to 56.
54 to 56.
56.
And annexure 11 is at page number?
Page number 43.
43. All right.
Yeah.
Then?
My lord, the police, allegation, my lord, the police have fired 11 round fire in the air and on 29/7/2013.
Yes.
Inside the room and outside the room. After hearing the sound of the firing, the unit in charge state additional inspector and other constable have caught him and transported him to Dhanbad police center. On observation, my lord, at that time he is mentally not sound. He was mentally not sound at that time. Accordingly, in such allegation, my lord, he was suspended from his service. Office order number 3391 dated 19/12/2013 and extract 2 model.
That's right. Then?
Then, my lord, departmental number. The petitioner was asked to submit his cause, so-called charge framed therein in annexure 4, my lord. Thereafter, my lord, arms are, a report has been said that arms are air firing within last 3 months. The report dated 22/10/2013. But
The firing was denied by you.
Where
Where is your reply?
It was nothing on
Where
record.
is your reply to the show cause?
Nothing was record. Record.
No, you tell us,
To
where is
show
your-
that to show that when the arms was taken.
No, you just tell us. You must have given a reply. You must have denied that you did not fire.
No, did not. I have not.
You fired.
Yes, ma'am.
It is an admitted fact that you fired.
Unconscious, madam. Mentally not sound.
Unconscious. So you were unconscious with the arms.
At that time, mentally
At
not
that
sound.
Mentally not sound, and therefore you fired.
Yes, madam.
So firing is admitted by you, isn't it?
Firing is admitted, but that was examined. That same rifle was examined or not. That is, my lord.
No, when you admit that you had fired, that's the end of the story. So whether the rifle was examined, not examined, it has got no relevance.
Yes, at that time, my lord, he was given continuous duty, my lord. In the night, 10 p.m. to 12 midnight.
Show us the
to 2
period
a.m.
of duty.
My lord.
What was the period of duty? Give the exact time and date. It must be there on record.
No, regarding that, my lord, in supplementary counter affidavit also not.
No, I'm just, it's your case, no, that you were being given continuous duty. So I'm just asking you, what was the continuous duty? So these details are not there.
Yeah, his details is not there. Timing is there. That
Where is your first reply to the show cause? That will reflect everything, isn't it? Where is your first reply to the show cause? Please answer to this query. Where is it? You have annexed or you have not annexed?
so
Your first reply to the show cause.
first reply on
Annexure 6, page 21.
expansion first annexure. Yes, mother. Annexure 6, 21 to 23. That is the first.
That's right. So firing is not in dispute. Page 21 to
23.
23. Then what happened? You tell us, where is the violation of natural justice? Mr. Manji, we cannot be so leisurely in arguing a case. I'm asking you a specific question. Your cases rest upon natural justice violation, right? Where is the violation of natural justice?
In memo, I think also memo.
You just tell us, you argue your case. At what stage there was violation of natural justice?
It's constituted. Now, kindly see, my lord, page 44 to onward, my lord. That is my memo of appeal, my lord.
No, not the memo of appeal.
My lord.
Not to the memo of appeal. You see, there are other stages. You must have been given the second show cause notice.
Yes.
You must have responded to the second show cause notice.
Yes.
Where is your response to the second show cause notice? That will reflect everything if there was any violation of natural justice. Isn't it?
Yes.
Where is your reply to the second show cause notice?
Second.
Annexure 10?
Annexure 10.
Yes.
No, ma'am.
Annexure 10, page
Yes,
44.
madam. Annexure 10, second super.
Now show us the
39 to-
violation of natural justice from this document.
Yes. I 39 to 42. No, it's a bill on second paragraph, so permission is a further amount.
No, memo. We'll come to the memo.
No,
Don't
sorry,
worry.
so my second soap was
Yes.
second soap was paragraph second. Internal page 2.
Yes.
संचालन पदाधिकारी महोदय द्वारा अपने विभागीय कार्रवाई संचालन के क्रम में मुझे दोषी प्रमाणित करने के लिए सिर्फ साक्ष्यों का बयान दिया है। वो भी ऐसी साक्ष्य जैसी प्रचारित और श्री विजय कुमार सिंह और प्रथम पुलिस केंद्र धनबाद श्री शंकर ओराम, ये दोनों पदाधिकारी न तो घटनास्थल पर थे और न ही घटना के देखे हैं। घटनास्थल पर मौजूद साक्षियों के बयान इस प्रकरण में ही लिया गया है जो मुझे निर्दोष साबित कर सके। ऐसी भी माननीय उच्च न्यायालय के निर्णय के अनुसार किसी भी दोषी के दोष का प्रमाणित करने के लिए कम से कम 2 साथियों को होना नितांत आवश्यक है, जबकि इस प्रकरण में प्रभारी श्री मंगरा ओराम जिन्होंने अपने प्रतिवेदन समर्पित किया है और साक्ष्य के रूप में अपना बयान दिया है, जो साक्ष्य ही नहीं वही कंप्लेन फाइल किया था, साक्ष्य ही नहीं हो सकते क्योंकि वे इस प्रकरण में वादी हैं जिनके लिखित प्रतिवेदन के आधार पर मुझे निलंबित किया था। ऐसे इस घटना के मात्र एक ही साक्ष्य आर्मोरल है। श्रीमान रांची तंत्रिका मनोचिकित्सा संबद्ध विज्ञान संस्थान रेनपास रांची द्वारा किए गए मेरी शारीरिक जांच उनके द्वारा जारी किए गए चिकित्सा प्रमाण पत्र को फोटोकॉपी प्रमाण के अवलोकनार्थ समर्पित कर रहा हूँ। श्रीमान उल्लेखनीय है कि संचालन पदाधिकारी श्री श्रीकांत उपाध्याय पुलिस निरीक्षक सिंदरी अंचल के द्वारा धनबाद जिला विभागीय कार्रवाई संख्या 13/14 में उनके द्वारा समर्पित की गई प्रतिवेदन के आधार पर श्रीमान ने मेरे विरुद्ध सेवा से बर्खास्त की संबंधित जवाब मांगी, जबकि नियमानुसार पुलिस सेवा में कार्यरत कर्मी जघन्य अपराध जैसे डकैती, चोरी, बलात्कार इत्यादि व्यक्ति को ही सेवा से बर्खास्त की सजा दी जा सकती है। शारीरिक रूप से स्वस्थ और अचानक मानसिक संतुलन बिगड़ जाने के कारण AK-47 से अचानक हवाई फायरिंग हो जाने से कोई जघन्य आपराधिक घटना न हुई है जिसके कारण सेवा से बर्खास्त किया जा सके। प्रमाण स्वरूप चिकित्सीय प्रमाण पत्र भी इसका उल्लेख है।
So where is the allegation of natural justice? That any natural justice has been violated?
तो सीमा से प्रार्थना उपरोक्त बिंदु पर सहानुभूतिपूर्वक विचार करते हुए दो लगाए गए आरोपों से मुझे
That's right. So after the submission of the inquiry report,
माना।
you were given second show cause notice.
Yes.
Now show us that where is the, I'm repeatedly asking you, where is the violation of natural justice in your second show cause report?
The petitioner has not been given opportunity to defense his case. Yeah, cross-examine का भी.
Where is it mentioned in your second show cause reply that you were not granted opportunity to cross-examine the witnesses? Is it mentioned? Second show cause reply is an opportunity to you with regard to the inquiry report. If you have any grievance that you were not given opportunity to cross-examine, What is the right stage where you will raise this grievance? Second show cause, isn't it?
That is specific, that has not been.
It is not there.
Exactly.
Not specific. There is no indication also.
But
You only say that the relevant witnesses were not examined, and you say that the complainant cannot be a witness.
yes,
So where is natural justice? From where do you allege violation of natural justice?
at least, so, a white paper में जो type copy में जो
But you
signature
see, you
करा दे-
cannot have it like this. You have to show that you raised this plea before the authority. We are under 226. And this is the reason you never raised this plea in the writ records also. Maybe in the memo of appeal.
Memo of appeal में
Memo of appeal में कोई पहली बार raise कर सकता है ये point. That you signed on blank paper before the inquiry officer. You will raise this point for the first time in the memo of appeal, or you will raise it at the stage of second show cause notice itself. Memo of appeal will see that what was your reply, what was the inquiry report, was there any violation of natural justice as pleaded by you in the second show cause.
इसमें mention at least मानो co-employee को at least अगर गवाही में लाता
तो आपको कौन मना किया था लाने के लिए? You could have brought him in your defense.
that was not
If there was a witness in your favor, you could have brought him in defense. And the factum of the incident is not in dispute. Right? And subsequently, you have been only compulsorily retired. It is not a case of dismissal. So, a person who is mentally unsound, mentally unstable, उसको राइफल दे दें घूमने के लिए. Fair enough. Should it done? 11 round. 11 people have died. Could have died.
But inside of the room,
Even one firing is sufficient. Even one firing for no reason is sufficient.
वही ये किया है मंगरा और लिखा था कि at that time mentally sound नहीं था.
So therefore, rightly, you have been rightly given the punishment of compulsory retirement. But means what?
But again, thereafter also I have been deployed.
You see, the matter has been remanded on the ground that you amended the writ petition by saying that there has been a violation of natural justice. Kindly demonstrate. Adjournment के अलावा कुछ भी prayer चलेगा. नहीं. No.
Thereafter also he has been deployed to his duty and.
What is his present age? What is his present age?
His maximum 30.
Maximum means you don't know his age.
He is 39 years as per the amendment made in the
Writ petition.
writ petition.
And this was filed in 2015. 49.
39.
39. So you are now 49 at least. Around 49 or maybe 47.
Amended petition.
Party position and all.
You demonstrate violation of natural justice, there is no problem. But you have to demonstrate violation of natural justice.
One prayer may kindly be considered, my lord.
I will consider all your prayer, don't worry.
Prime Minister जब आए हुए थे visiting में उनको दिया गया था ड्यूटी में.
बहुत गलत कर दिया. Mentally unstable लोगों को अगर प्राइम मिनिस्टर के ड्यूटी में दे देंगे तो बहुत सीरियस बात है.
But my lord, he has done his duty.
No, you have yourself said that you were mentally unstable. You were under treatment in Rinpas.
At that very time.
Yes.
Thereafter,
So suddenly your mind becomes mentally unstable.
Thereafter, my lord, certificate issued to the petitioner from the Greens, my lord. He was then, my lord, he is fit to resume his duty.
You see, the matter has been remanded on account of the fact that there has been a violation of natural justice. Because you amended the writ petition. Kindly satisfy this court. On the point of violation of principles of natural justice. I will listen to that only, no, because that has been remanded on this ground. I am repeatedly asking you this question. Show me the violation of principles of natural justice.
No, that is in memo of the bill that is there, my lord. In first suppose, second suppose, that is not.
So it's
been
an
mentioned, my lord.
afterthought. It is clearly an afterthought. In the memo of appeal also not there. You filed a supplementary memo of appeal where you raised this point,
Yes.
isn't it? In the original memo of appeal also it is not there.
Layman.
Layman, you are a layman. Illiterate. No.
No, my lord, the petitioner at that time, you suppose file किया तो उसको मैं बात बोल रहा हूँ. And now he is fit, quite fit. Certificate has been given by the deans, my lord.
You cannot be entrusted with arms. Because your
The
mind
harsh
can become
punishment,
unstable.
my lord,
anytime.
only 3.5 years he has done his duty, my lord. Only your whole life is. Doing, my
They have
lord.
not dismissed you. They have just compulsorily retired you. You must be getting pension.
But no monetary benefit, only 3.5 years, my lord, he has done duty. Dismissal and removal of service, then the same effect, my lord.
Where
For-
is the
for-
memo
for
of
his-
appeal?
for-
Where is the memo of appeal in which you have raised this point?
Yes.
Show me the memo of appeal as well as a supplementary memo of appeal. Where is it?
On supplementary counter affidavit, annexure Q to
No.
the main first memo of the appeal. Q. Supplementary. 89. Supplementary counter affidavit, my lord, 80, 89. 89, supplementary counter.
Where is the memo of appeal?
This is memo of appeal, my lord. Immediate.
Page number?
Page number 89 of the supplementary counter appeal.
Yes. Where is the point raised?
Paragraph 3, my lord. वही continuous duty का ये बारे में दिया
Yes,
है
that.
इसमें।
Where is your violation of natural justice?
उसके बाद पैरा 7 में है ये कि सीमांत पुलिस अधीक्षक द्वारा मेरे सर्च पर स्वास्थ्य चिकित्सा चौकों द्वारा प्रस्तुत रिपोर्ट की अनदेखी की गई है और आदेश पारित करते समय मेरे द्वारा प्रस्तुत बचाव में दिए गए तथ्यों एवं प्रमाणों
That is a very general statement. Where is the natural justice violation?
पैरा ये कि सीमांत पुलिस अधीक्षक के मेरे के पारित आदेश प्राकृतिक न्याय के सिद्धांत
ये तो no. You have to specify, no, what natural justice has been violated. How natural justice has been violated.
That was not considered, my lord. That
No, you have to-
health regarding the health and
That is your case that you were mentally unsound. That was your defense that you were mentally unsound. Otherwise, you would have been dismissed.
my lord, second memo of appeal. Second.
In the original memo of appeal, when did you file it? 9th February 2015.
Ninth.
When did you file your second memo, supplementary memo of appeal?
Annexure 12, my lord.
Of the?
Read petition, my lord. 44 to 53.
And when did you file it? Referring to all the Supreme Court judgments. You have referred to lot many Supreme Court judgments. This is on 4/3/2015, right? Sansodhit memo.
4, 3, 50. Received.
4/3/2015.
Yes.
Where is it mentioned?
para 15 हमारा para 15 page 50 internal page 7 में memo
Internal. Okay.
महोदय इस विभागीय कार्यवाही से सौगंधी मंगलावरण परिचय खबर तथा रोनी प्रथम पुलिस केंद्र थाना गवाह है दिनांक 2/3/2014 को इन तीनों की गवाही या हुई है पहले से टाइप किए गए इनका बयान मेरे समक्ष लाए गए और मुझे इन पर हस्ताक्षर करने को कहा गया है मुझे स्पष्ट कहा गया कि जहां तुम्हारा नाम टाइप किया गया है वहां पर हस्ताक्षर करना है और किसी भी गवाह से जिरा नहीं करनी है यदि गवाहों से जिरा करोगे तो जल्दी ही सेवा से बर्खास्त हो जाओगे मैं एक सीधा साधा असहाय पुलिस हूँ मैं इनकी बातों में आ गया और मैंने पहले से टाइप किए हुए बयानों पर हस्ताक्षर कर दिए Then I was 16.
So it's a, yes, I got this. So therefore, before the inquiry officer also there was no objection taken. At the stage of second show cause also no objection taken. At the stage of filing the first memo of appeal, no objection taken. You take this objection for the first time by filing this second memo. Explain. Is it not a case of afterthought?
पैराग्राफ 16 में बेमान मुझे डरा धमका कर गवाह से बयान
ये डरा धमका के तो इंक्वायरी ऑफिसर के सामने नहीं बोले सेकंड शोकॉज में भी नहीं बोले ओरिजिनल मेमो ऑफ अपील में भी नहीं बोले अचानक ये मेमो ऑफ सेकंड मेमो ऑफ अपील में डराने धमकाने का कहानी कैसे आया इज इट समथिंग व्हिच वाज नॉट विद इन योर नॉलेज इज इट समथिंग व्हिच इज न्यू यू हैव डिस्कवर्ड
इसके बारे में
डराना धमकाना एक पुलिस ऑफिसर है डराना धमकाना ही से यू से इनोसेंट उसको डरा धमका
कुछ दिन खाली सर्विस था वो डर गया था जब हमको डिसमिस कर दे इसी कारण से वो कुछ नहीं कर पाया
वो भी कहां से बोल रहे हैं See, you cannot.
It is not on record. Only in memo of appeal that has been mentioned by me.
I've seen. You say that you are an innocent person. You do not know much law, but you have referred to so many judgments. You have referred to Article 14. You have referred to various judgments.
Yes, ma'am.
You say that you are innocent. You do not know law.
At that time,
So this has been.
This is consult करके.
Yeah, that's why it is a consulted, revised memo of appeal wherein you have raised a new ground altogether.
Not new ground, but that he was innocent at that time. Might not.
That's all. Yes, you are.
Your Lordship, since the matter has been remanded by the appellate court on the point of natural justice, Your Lordship, there is no violation of principle of natural justice which is apparent from the record as because the due procedure established by law has been duly followed by the respondent's authority, Your Lordship. If Your Lordship would kindly come to page number 65 of my supplementary counter affidavit, I will demonstrate, Your Lordship, there is no violation of principle of natural justice.
Page number?
65 of my supplementary counter affidavit.
65.
Annexure J series. These are the statements which were recorded, and in the statement, if Your Lordship would see, the petitioner himself have signed all these documents. This was recorded before the inquiry officer, Your Lordship, which bears the signature of the petitioner himself. If at all, if he had any objection, after the inquiry report was furnished to him, at the time of filing of second show cause reply, he should have taken the specific plea in his second show cause reply that he had never been given an opportunity for cross-examining these witnesses. Now at the fag end of the departmental proceeding, just to develop his case, he has come up in the second memo of appeal that I was never given the opportunity to cross-examine. nowhere in the second show cause reply, no avowment has been made with regard to that the petitioner was never given an opportunity or he was coercively made to sign these documents, witness documents, Your Lordship. All the
Annexure, page 71, when he was final defense, when he was supposed to give his final defense,
yes, Your Lordship.
he said that मेरे द्वारा समर्पित बचाव अभिवेदन को ही अंतिम बचाव अभिवेदन समझते हुए order passed.
Order passed.
At that point of time also he raised
He
no
didn't
objection.
raise any objection, Your Lordship. He had stated that my first show cause reply should be treated as my second show cause reply. And it is just an afterthought of the petitioner just to develop his case that he was never given an opportunity for cross-examination of any witness or he was forcibly made to sign these documents, Your Lordship. All the due procedure has been followed.
He has been removed from service or compulsorily retired?
He has been removed from service. Initially, he was dismissed from service. Thereafter, he was reconsidered, and he has been granted removal from service.
Okay. The appellate authority has given him the punishment of removal from service?
Yes, Your Lordship. And first show cause reply has been served to him. Second show cause has been duly served to him. Inquiry report has duly served to him. The punishment order has also been served to him. There is no violation of any due procedure established by law in the departmental proceeding, Your Lordship. And this plea has been taken that there is a violation of principal natural justice, which he should have been taken because second show cause reply is given to the delinquent only when if he has any objection before passing of the final order.
For the learned counsel for the parties.
Well, 71, page 71, and my lord, witnesses, ये पर जो signature किया है, on the same date, my lord, 1905 में, जो लिखा है उपरोक्त प्रश्न सब विषय के संबंध में, मुझे कहना है कि मेरे द्वारा समर्पित प्रथम बचाव अभिवेदन को अंतिम बचाव को अभिवेदन समझते हुए मुझसे दोष मुक्त करने की कृपा प्रदान की जाए, on the very same date.
There is no objection to this. You have not objected to this. You have not said that this also was forcibly taken from you. That is not your case.
No, one thing, my lord, it is too harsh punishment. Only 3.5 years I have done.
See, we cannot take risk.
Demand.
We cannot take risk with those persons who are mentally unstable and who has. No, you never know when your mind becomes unstable, isn't it? 11 round. In a mental unstable state, you suddenly became unstable. We can't take risks.
Now, fit, my lord, that certificate
We
is
see,
given, my
Mr.
lord,
Manji,
and
we
as
have
an
to
exer-
go. We have to go strictly as per law, right? If the law permits you to be immediately restored in service with all consequential benefits, I would have done it. That is why I am hearing you so patiently, because the Honorable Division Bench has allowed the amendment at the appellate stage, right? So therefore, I have to be all the more careful that there has to be something very serious regarding violation of natural justice. I am hearing you for half an hour. And putting you all the questions, making my mind very, very clear where my mind has got stuck. So I need to know. You have no explanation as to why have you taken this point at such a belated stage in the second round of appeal which you have filed. There is no explanation from your end on this.
One thing, my lord, if possible, madam, service में कम से कम reinstate करके
See, I do not know.
diasman करके continuation.
I do not know any sympathy beyond law. I may be very unpopular because of this, but I do not know any sympathy beyond law. If you have a case, you will get it fully. We are not doing any charity to you. Right? I will dictate it in the second half. You be there. Both of you, you be there. Right? I will dictate this order in the second half. Maybe at 3:30 I will dictate. Okay, 3:30, or I think I'll take half an hour. At 4 o'clock I'll dictate the order.
किसी भी कर्म में consider नहीं किया जा सकता. Law में तो.
आप हमको law बताइए, Mr. Manji. I will consider everything. You see, I'm absolutely with you. I'm absolutely with you. Show me some law that I can grant you any relief. You have done a very.
Unfortunate, my lord. That was not.
I know it is unfortunate that you have fired 11 rounds for no purpose. It is very unfortunate.
Whole life will be going.
You have just been removed from service. You can take alternative job also. There is no bar.
Without arts में भी नहीं दिया जा सकता है.
हम लोग उस तरह से ऑर्डर नहीं कर सकते हैं. आप आर्ग्यू कर सकते हैं, हम लोग वैसा ऑर्डर नहीं कर सकते. But you be there in the second half. I want the order to be dictated in your presence because there are so many things which I have to write, to which you do not have an answer. Right? Don't be absent in the second half. 4 o'clock. Till next.
So case item 7, WPC 7479 of 2013.
The list of dates when diagonal lordship said something earlier. This cooperative society was registered melody in the year 1929. Then melody on 25th of July 1995, the Reserve Bank granted license to the Dhanbad Central Cooperative Bank under section 22(1) of the Banking Regulation Act to carry on the business of banking. Then on 8/10/2002, there is a proposal by the state government. Proposal before the state government to take a cabinet decision for amalgamation of the 8 district banks from 3 tiers to 2 tiers. It was a proposal with page kya hai. So this I will be explaining because there is no resolution on the board which has been brought on the record by the respondent. It is second supplementary counter affidavit that we have record.
You filed your rejoinder, no? You filed your rejoinder.
नहीं हम कोई rejoinder.
So you have decided not to file it. We can't do anything about it. Yes, continue, please. Yes, next. Next, please.
May I say, Melody, in that case,
No, please, I will not adjourn it. We are hearing it. We are in the midst of hearing it.
right. Well, that I will be sorry.
Continue, please. Please proceed.
But first this letter I just want to show to you, Lord, 8/10/2002. Let us see. That is second supplementary affidavit of the state government dated 13/3. Page 18. Page 18. Starting from page 18, this is the letter. This is झारखंड राज्य सहकारी बैंक लिमिटेड की स्थापना के संबंध में मंत्री परिषद के लिए संलेख. So I put a stress on the word when this document has been produced by the respondent. and I put a stress on the document, there's some lake, and they described there are 8 district level banks, 1, 2, 3, 4, 5 in that Sundays, and thereafter, your lordship may kindly come to page 18. Internal page, क्या page? 28. 23. Lordship, kindly come to page 23. आ गए। ये तो 20 है। Lordship, kindly come to page 20. The heading starts प्रस्तावित द्विस्तरीय व्यवस्था. Heading of the page, because the pages are it has not been given by the respondent. Heading is number 4, प्रस्तावित द्वितीय स्तरीय व्यवस्था, and in that column they have referred 8 district level cooperative societies: Ranchi, Gumla, Chaibasa, Giridih, Devghar, Hazaribagh, then Dhanbad, Dumka. So far up to Devghar is concerned, net worth, another heading is net worth, all are in minus except the bottom 2, that is Dhanbad and Dumka. The Dhanbad, the net worth is more than that, that's why this I wanted to show them with their document. Then your lordship kindly come to the last page of this Sun Lake. Paragraph 8 of this Sun Lake. Page 23. Paragraph 8. त्रिस्तरीय, I will not got that one.
Yes.
त्रिस्तरीय प्रणाली पद्धति को समाप्त करते हुए द्विस्तरीय प्रणाली पर आधारित राज्य सहकारी बैंक के गठन प्रस्तावित है। द्विस्तरीय प्रणाली के तहत राज्य सरकारी बैंक एवं राज्य के जिलों में इसकी शाखाएं होंगी। 8 कार्यरत जिला सहकारी बैंक यथा रांची खूंटी केंद्रीय सहकारी बैंक लिमिटेड, गुमला सिमडेगा केंद्रीय सहकारी बैंक लिमिटेड, गुमला सिंहभूम सोनसो, चाईबासा हजारीबाग लिमिटेड, देन धनबाद is there, धनबाद केंद्रीय सहकारी बैंक लिमिटेड धनबाद, दुमका केंद्रीय सहकारी बैंक लिमिटेड दुमका, देवघर जामताड़ा सहकारी बैंक लिमिटेड देवघर एवं गिरिडीह केंद्रीय सहकारी बैंक लिमिटेड गिरिडीह का आमेलन अमलगमेशन राज्य सहकारी बैंक में कर दिया जाएगा एवं इस कार्यरत सहकारी बैंकों की शाखाएं राज्य सहकारी बैंक की शाखाएं हो जाएंगी। अंकित जिला केंद्रीय सहकारी बैंकों का एसेट्स एंड लायबिलिटी राज्य सहकारी बैंक की होगी तथा पदाधिकारी कर्मचारी भी राज्य सहकारी बैंक हो जाएंगे। कंडिका सो राज्य सहकारी बैंक के लिए अतिरिक्त वित्तीय बोझ राज्य सरकार पर नहीं होगा। राज्य सहकारी बैंक के गठन के पश्चात बैंक को इकोनॉमिकली वायबल बनाने के लिए आवश्यक कार्रवाई की जाएगी। 9 प्रस्ताव पर विभागीय मंत्री माननीय मुख्यमंत्री का अनुमोदन प्राप्त है। प्रस्ताव पर वित्त विभाग की सहमति प्राप्त कर ली गई। प्रस्ताव पर विधि विभाग से परामर्श प्राप्त कर लिया गया। समलेख की कंडिका 8 के अनुसार प्रस्ताव पर मंत्रिय परिषद की स्वीकृति प्रार्थित है। So it was a proposal for the approval of the cabinet. So this is not the decision of the state government. And the same at the bottom, the same यहाँ 5,733 8/10/2002 को they are trying to enforce without having any approval of the cabinet. If there would have been any approval of the cabinet, it was for them to bring on the record in view of the section 106 of the Evidence Act, because it was within their special knowledge. Then, my lord, item number 4 on the first page, my lord. On 31st of December 2006, the respondent number 4 bank was superseded. My lord, this fact is not on the record of this case, I must say in all humility, my lord. But this
Things
matter
which are
was
not
before,
on record.
my lord,
Please do not
only because the matter was before this honorable court in another proceeding and the judgment has been delivered in that case. That's why it is my responsibility and
Which
duty.
judgment are you relying upon?
Pardon?
Which judgment are you relying upon?
Yes. Order.
So one is that there is no approval.
One is there is no approval.
Second point?
The second point is उसका हम judgment दिखला देंगे.
No, you just formulate the point and then.
Yes. List of dates दिखला देता हूँ. Points भी formulate किए हम.
Point formulate तो हम लोग किए थे ना एक बार पहले.
हाँ,
या कोई नहीं, वो आप लोग कर ही नहीं पाए. बहुत अच्छी बात.
Points हम लोग formulate किए हैं. That I will have to pass it on. First
I
time
don't
on.
know. It's all specific orders होता है. आप लोग को formulate करने के लिए. You do not do that. Other side has not even been served with that.
And then just we have given it. Just.
What is the second point? when you are referring to the point, either you refer to the point formulated or you argue. When you have formulated the point, you refer to the point formulated.
Well, the fact has to be brought to your lordship's notice first.
So you first was regarding approval of cabinet. Do you want to say anything more on that?
And that may be related back to Annexure 3, which has been impugned.
See, when you raise a point regarding no approval, kindly complete all the related arguments relating to that point.
हम चाह रहे थे कि पहले फैक्ट डिटेल दे दें उसके बाद.
नहीं, हम आपको लग रहा है फाइल ही पढ़ के आए हैं.
नहीं
फैक्ट पढ़.
ये that I know.
इसलिए आप फॉर्मुलेट करिए. आई एम हियरिंग यू.
Your lordship kindly come to Annexure 3.
Annexure 3 to the main writ petition.
Main writ petition, page 31. जी. Annexure 3, page 31.
This is the impugned order.
Yes. Yeah, that is the 3 and 4 both are. Your lordship kindly permit me to place it, because that speaks so many things.
We read it full text on the last date.
But once, since now we are confined.
No, I recollect it. Anyways, you read it if you want. It's an impugned order, so we need to read it again.
झारखंड राज्य गठन के पश्चात शीर्ष सहकारी बैंक के रूप में राज्य में झारखंड राज्य सहकारी बैंक लिमिटेड का गठन करते हुए भारतीय रिजर्व बैंक नाबार्ड के आदेश एवं परामर्श पर बिहार राज्य सहकारी बैंक लिमिटेड पटना के झारखंड स्थित 5 शाखाओं का हस्तांतरण राज्य सहकारी बैंक में किया जा चुका है. दिनांक 1/9/2012 से झारखंड राज्य सहकारी बैंक लिमिटेड कार्यशील है. साथ ही झारखंड राज्य सहकारी बैंक लिमिटेड को बैंकिंग व्यवसाय हेतु भारतीय रिजर्व बैंक के द्वारा बैंकिंग लाइसेंस भी प्राप्त हो गया है. इस प्रकार झारखंड राज्य सहकारी बैंक लिमिटेड पूर्ण रूप में कार्यशील हो चुका है. दिस इज द बैकग्राउंड. देन हियर कम्स राज्य मंत्री परिषद की बैठक दिनांक 8/10/2002 I have shown to your lordship कि that is not that was a proposal given to the मंत्री परिषद में लिए गए निर्णय के अनुसार राज्य में द्विस्तरीय प्रणाली सहकारी शाख संरचना को लागू करने हेतु झारखंड राज्य सहकारी बैंक से सभी 8 जिला केंद्रीय सहकारी बैंकों का अवमेलन करने के लिए झारखंड सहकारिता अधिनियम 135 की धारा 44(1) के प्रावधान के आलोक में भारतीय रिजर्व बैंक के द्वारा भी सैद्धांतिक सहमति प्रदान की गई है एवं इस प्रकार कार्यालय के पत्रांक 2746 दिनांक 21/10/13 के द्वारा राज्य अंतर्गत सभी जिला केंद्रीय सहकारी बैंकों को झारखंड राज्य सहकारी बैंक में सम्मेलन के लिए बैंकों के बोर्ड प्रशासक एवं आम सभा से सम्मेलन की सहमति संबंधित प्रस्ताव पारित करने हेतु निर्देश दिया गया। उक्त आलोक में धनबाद केंद्रीय सहकारी बैंक लिमिटेड को छोड़कर शेष 7 जिला केंद्रीय सहकारी बैंकों के द्वारा सम्मेलन पर सहमति व्यक्त करते हुए तत्संबंधित प्रस्ताव पारित कर दिया गया। So this they are deciding without having any cabinet approval. It was just a proposal. Only concerned minister has approved, chief minister has approved, but the cabinet has not approved. And that fact, if that would have been there, it was for the respondent to bring for your lordship. They have brought on the record only the proposal. ज्ञातव्य हो कि राज्य में द्विस्तरीय प्रणाली अपनाए जाने से बैंक समिति की वित्तीय स्थिति सुदृढ़ होगी एवं इस बैंकों के सदस्य समितियों के साथ कृषकों एवं ग्राहकों को बेहतर बैंकिंग सेवा ग्राहकों को बेहतर बैंकिंग सेवा भी उपलब्ध हो सकेगी। इसके अतिरिक्त सहकारिता क्षेत्र के तहत कृषकों को कम ब्याज पर कृषि ऋण इत्यादि उपलब्ध होगा। I am making a comment also for this proposal is concerned that all 6 out of 8, 6 were in loss. So how they want that it will be sudrid? And they have amalgamated 7 persons, including Dunka, which was just in minor margin of profit. उपयुक्त तथ्यों पर सम्यक विचारोपरांत यह स्पष्ट है कि धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में सम्मिलित किया जाना दोनों बैंकों समितियों के वित्तीय सुदृढ़ीकरण हेतु आवश्यक है एवं यह दोनों बैंकों एवं किसानों, मजदूरों एवं ग्रामीण हस्तकारों के लिए हितकर। So they want that the one bank which is in the profit to amalgamate with the other banks which are in loss, and meaning of which will be that they want to put this bank in a jeopardy, the interest of the bank in a jeopardy. एक आदमी जो ठीक चल रहा है उसका भी टांग तोड़ के लंगड़ा कर दिया। Yes, then next line here the partial line so far we are concerned. ऐसी स्थिति में झारखंड सहकारी नियमावली 1959 के नियम 39 के तहत धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में अनिवार्य सम्मेलन किया जाना आवश्यक है। अतएव उपयुक्त तथ्य से संतुष्ट होकर बैंक समितियों के वित्तीय हितों को दृष्टिगत करते हुए झारखंड सहकारी नियमावली के नियम 39 के तहत धनबाद केंद्रीय सहकारी बैंक के बैंक प्रबंधन को आदेश दिया जाता है कि धनबाद केंद्रीय सहकारी बैंक को झारखंड राज्य सहकारी बैंक में अनिवार्य आंदोलन संबंधित प्रस्ताव पर विचारोपरांत निर्णय के प्रयोजन से बैंक के शेयर धारकों एवं लेनदारों की आम सभा अधिकतम 6 सप्ताह के अंदर आयोजित कर लिए जाने के प्रस्ताव से अधो हस्ताक्षरी को अवगत कराना सुनिश्चित करें. So this is the direction contained in the letter. So first, my lord, we have told that this annexure 3 is based on a fact which do not exist at all. They say that there has been a decision of the cabinet, but in fact it is not a decision, rather it was a decision, it was a proposal to be placed before the cabinet, and the state being having the special knowledge about the cabinet decision, it was their responsibility to bring the decision of the or resolution of the cabinet. And even merely cabinet decision is not enough. Rules of executive business, my lord, so far I know I cannot say the exact clause of that. Rules of executive business says that the cabinet's decision is not ipso facto binding unless it is issued by the competent authority or some secretary as a resolution of the state. And that has to be put in gazette also. A cabinet decision merely on file it becomes effective only if it is gazetted, issued through the proper resolution under the signature of the some competent secretary. So this is so far the annexure 3 is the first point, that it is based on the misconception of fact or misleading fact. The second is, I will be elaborating this part later, and our second argument which we have said, that the rule 39 is not.
Please don't shift to a distinct argument altogether. When you raise a point, you complete your point.
So far this fact is concerned, this submission is concerned, it is complete, that there has not been any notification of the decision of the cabinet by the state government. It was just a proposal, and the annexure 3 is bad on that aspect, misleading, contains misleading fact. Now the second argument is that Rule 39 of cooperative rules is not applicable so far the banking cooperatives are concerned. And doing banking business, the only under the license of the Reserve Bank of India, because there is a special chapter in the Cooperative Act, that is chapter 6B. 6, a special chapter under the Cooperative Society Act, that is chapter 6B of the Cooperative Society Act.
Book 86. Okay.
Page 86. This chapter contains section 44AJ to section 44AO. Then you can permit me to place this. So far 44AJ, 44AK and the 44 AO. Section 44 AK. Division
You said AJ also.
AJ. AJ.
Please read it sequentially.
Application of the chapter to cooperative banks. The provision of this chapter shall apply to a cooperative bank as defined in the Deposit Insurance Corporation Act 1961, so and so, in addition to the provisions contained in other parts of this act, where any question of apparent or implied inconsistency arises, the provisions of this chapter shall prevail over the provisions of the other parts of this act. So this part or this chapter, provisions contained in this chapter will be applicable so far the bank is concerned, and the other provisions in the act which are inconsistent with the act.
Cooperative bank as defined in the Deposit Insurance Corporation Act. Are you covered by this? Not covered.
So far this bank is concerned, it is covered with this license case.
So it is covered by this term. Cooperative bank as defined in Deposit Insurance Corporation Act 1961. Right? Then continue please. No, we will take your words. Don't worry about it. Yes.
Banking institutions. Deposit Insurance Corporation Act 1961. I will have to check. I'm
You
sorry.
are placing the section that is the basic ingredient of the section, and you say you have to check.
This Deposit Insurance Corporation Act.
This is the basic ingredient of the section, and you are clueless on this.
For the timing, your lordship kindly.
How will I apply my mind to the section?
Just a minute. Deposit Insurance Corporation. Just.
It is not your case that this chapter is not applicable.
Probably
Nor it is your case that this particular section is not applicable. It is not your case.
No, our case is that Rule 39 is not applicable.
Rule 39 is separate.
Not applicable
But this
because-
chapter is not applicable. That is not your
that
case.
we say that this chapter is only applicable.
That's
Yes.
So at least when this chapter is applicable, the very applicability of the chapter is that it should be covered by that insurance act. So we take it that it is, according to you, it is covered by this chapter.
हम फिर भी उसको वेरीफाई कर लेंगे
You cannot
Proceeding.
have a conflicting stand in
Let's
in
say
argument.
I can't have, my lord, I can't have.
When the basic ingredient of the section you are disputing, and then it is not
No,
your
I am
case.
not disputing, I am accepting it that this is applicable.
So
This
it's
is
okay.
applicable.
If it is applicable, then everything is applicable.
Yeah, exactly.
Next, continue please.
My lord, then 44 AK. Subsection 2 भी इसका 44 AJ का देख लिया जाएगा. For the purposes of this chapter, Deposit Insurance Corporation means the Deposit Insurance Corporation established under the Deposit Insurance Corporation Act, and Reserve Bank means the Reserve Bank of India. That is the definition they have said. Then 44 AK, division, amalgamation, compromise, etc. No order sanctioning a scheme of compromise or arrangement or of amalgamation or reconstruction or of division or transfer of assets and liabilities of a cooperative bank shall be made without the previous sanction in writing of the Reserve Bank. So first hurdle for the respondents is for amalgamation, as they say that you will have to hold a meeting within 6 weeks for taking a decision for amalgamation. So this creates a hurdle in the way of the respondent melody and Annexure 3, which cannot be acted upon or cannot be decided upon without having the approval of the Reserve Bank of India as required under Section 44 AK. Where an order of moratorium has been made by the central government, that rest are not very material. The Section 144 AK, subsection 1 is the main subject.
Subsection 3 is also important. Can you read?
Yes, notwithstanding anything to the contrary contained in this act, where a cooperative bank being an insured bank within the meaning of Deposit Insurance Corporation Act 1961 is amalgamated or in respect of which a scheme of compromise or arrangement or reconstruction has been sanctioned, and the Deposit Insurance Corporation has become liable to pay to the depositors of the insured bank under subsection 2 of section 16 of the Act, the bank within which such insured bank is amalgamated, or the new cooperative bank formed after such amalgamation, or as the case may be, the insured bank or the transferee bank shall be under the obligation to repay the Deposit Insurance Corporation in the circumstances to extent and in the manner referred to under section 21 of that Act. So this is in case, this is the subsequent event. Subsection 1 is the primary situation, and the subsection 3 comes later. So far the Act which say there is a provision section 2, section 2B. 2B defines the bank, and 2DD is the banking corporation. DD banking companies. Section 2A says banking. Banking means the accepting for the purposes of lending or
Section 2A
Section 2A, the banking
of 1935 Act.
Yes, the corporate Deposit Insurance Corporation Act.
So the moment you say that you are governed by this chapter, you are governed by this act also.
Why?
So as simple as that. We don't need to go
Since
to
your
that.
lordship put a query and
I just It is a natural query. It is not your case that you are not
certain-
governed by that chapter.
No.
You cannot wriggle out of the
No,
fact.
no, I'm not wriggling out.
So-
I'm just wanted to be confirmed.
That's
My lord, this.
There is no need to refer to that act because you are governed by that act.
Yes,
There's no
yes,
doubt
yes.
about it.
The cooperative banks means the state cooperative banks, a central cooperative bank, and a primary cooperative bank. DD. Section 2 DD defines मेथड of the insurance. Insurance वाला जो है, इसमें Section 2 DD defines the cooperative banks. So therefore we are part of that. Your Lordship may take now in your, my statement to that.
You can be a little fast, Mrs. C.
Hello,
I'm taking all notes. Don't worry about it. And as it is, everything is recorded. I can always go back to the video and see. There is no problem.
I will try. I will try. I will try. I will try. First,
You cannot, you see, you
this,
cannot, I'm giving you a patient hearing, but it cannot be, leisurely done. You can continue with your hearing. I'm receptive to every argument and I'm recording every argument, of course.
I feel, my lord, that oblige, my lord, for your lordship's observation, my lord, and I do not want to waste your lordship's time or court's time, my lord, but since the stakes are very high, that's why.
That is why I'm giving you a hearing.
Yes, oblige, my lord, and the stakes are very high. Why? Because this is the third step the state government is taking to capture this bank. Third step. First step, my lord, that's why I wanted to show to your lordship under the list of dates. The first they took action under section 2U of the NABARD Act. They failed.
That is separate altogether. How many steps they are taken?
And this is the and
You
second.
were on the second point. You were referring to the provision of law. Kindly refer to the provision of law. Straight away come to the point that Rule 39 is not applicable.
Yes, exactly.
Yes. Kindly
Then-
explain.
Then, my lord, I have shown, my lord, that without intervention of the Reserve Bank, my lord, no decision can be taken by the state government, and we are running under the license of the Reserve Bank Reserve Bank. So, then 39, your lordship, kindly come to Rule 39. The compulsory amalgamation of the society. If the registrar is satisfied, after taking.
I don't have it in English. I have it in Hindi. In which page of this book it is there?
Oh, 39.
It is there in this book? This one?
Yes.
ये पुराना किताब में है.
Rule 39.
159.
Okay. Yes.
Mind. If the registrar is satisfied, after taking into consideration the financial position of two or more societies, my lord, your lordship kindly consider, not the bank, society. I have already indicated there are three types of cooperative sectors, my lord, the primary tax, lamps, and then when at district level and then the state level. So it talks about, according to me, it talks about the society, the primary level, and other matters, and such other matters relating to these societies as may be proper, that it is in the interest of those societies to be amalgamated into a new society, he may by order in writing require the managing committee of the societies concerned to convene general meeting of the shareholders of the creditors thereof, within 6 weeks from the date of the order for the purpose of considering the proposal of amalgamation of the society into new society. So this do not say specifically about the banking society or central cooperative banking society. And thereafter the consequential orders are there. If the managing committee fails to call any such meeting for the purposes, or if the decision in any such meeting is against the proposed amalgamation, or no decision is taken at any such meeting, the registrar may, on the expiry of the 6 weeks from the date of his order, and after satisfying himself that the interest of the creditors has been adequately safeguarded, direct that the said society shall be amalgamated into new society with effect from the date to be specified in the direction. So again, it is talking about the society, not the banking cooperatives or banking society, because they are taken on the different pedestal. Bankings are taken on the different pedestal, and this is about the society at the primary level. So therefore, my submission is that the rule as it is there, it has to be read, and this indicates that it is in relation to the society first. And the second, if it is presumed that it is a binding on the cooperative society, then it is just in conflict with the statutory provision as contained in section 44 AK. So in that situation, the provision of the act will prevail, not the rule will prevail so far the cooperative society. If the rule in that situation has to be read down that it is not applicable to the banking cooperative society. Even if it is treated to be the valid, then it has to be read down. I think
The validity of that rule is not under question.
no, can't be.
There is no prayer also to read down this.
No, we said that it is not applicable. We said about
That has to be decided whether it is applicable or not.
its applicability.
What else?
Then, so far this chapter is concerned, but the second point is concerned. The bank, the license of the bank is at pace. And that is annexure 3 to the counter affidavit. Annexure C to the counter affidavit filed by the respondents.
What do you want to show from there? First you say that what do you want to show,
No,
then I will.
from the license we want to show a statutory provision, under which provision the license has been granted to the petitioner bank by the Reserve Bank. That provision.
There is no problem about it. There is no dispute that license has to be granted, and there is no dispute that license has been granted.
No, under which provision the license has been granted, Madam Annexure C.
So what is the relevance of that? You just tell us.
A statutory provision has been quoted in that.
Fair enough. There is no problem about statute regarding
Like grant of license.
Grant of license, and then without license they cannot operate. No financial, no bank can operate without a license issued by the state.
Only very small words, if you not kind of they say, in exercise of the powers conferred on the Reserve Bank of India by section 22(1), read with section 56(o) of the Banking Regulation Act 1949, the Dhanbad Central Cooperative Bank, Bihar, is hereby granted license to carry on the
all the banking licenses are granted under this provision. I've seen so many licenses.
Exactly.
So there is no problem about it. There is no dispute on that. There is nothing, you see. You argue the points you want to argue. You need not read each and every page, each and every document, each and every
just
word.
indicating.
Yes.
Then
You complete your second point. First point I have noted, you complete your second point. That Rule 39 is not applicable.
Not applicable.
I have recorded.
And Then my lord, the procedure for amalgamation in the banking regulation, there is another procedure. Banking Regulation Act 1949, my lord, the section 44A is relevant. 44A, Banking Regulation Act. Last time.
Lordship have noted that.
Which point is that amongst the points that you have raised here? It will be covered under which point? There is no such point raised in your petition. There is no
Whether the
such-
banking, cooperative banks are governed under chapter.
There is no such point raised in your writ petition. There is no such point raised in your writ petition. Please do not argue your such matters,
No.
such point which are not born from the writ records.
Well,
You
relevant.
cannot, no, it's okay, but we cannot have a roving inquiry regarding all violations, all provisions. You have to raise specifically. Your specific cases, Rule 39 is not applicable. I
applicable.
appreciate that.
Yes.
But
Well,
to all these
one
points,
more
there is no end to it, Mr. Singh. We
one
cannot
stat-
expand the scope of the writ petition beyond what you have pleaded.
One statutory provision, my lord, we are also.
Even if it is a statutory provision, you see, even if there is a violation of statutory provision, even if it is in conflict with any statutory provision, you have to plead at least, because they have not been put to notice to such kind of a pleading. You cannot have a general kind of, argument like this. You have to confine your arguments to whatever is coming from your writ records and no more. We cannot permit like this. This is your main point. Rule 39 is not applicable. If Rule 39 is not applicable, the impugn order goes simply. As simple as that, right?
Well, certainly, my lord, the impugn order goes, my lord. And one more fact, my lord, this I wanted to show. So far, this bank is concerned that this matter was taken into consideration by this court. We have referred in the short notes. This was the order passed. We begin other side to give you. Exactly, my lord, this was the second stage of this. So far, this bank is concerned when the state government tried to take control over the bank. My lord, this was in relation to this very bank. Your lordship kindly permit me to place very short order, where the bank, state government took a resolution to merge it, and then they took it back. That is LPA 80 of 2009.
Where is the order of the writ court? WPC number 4949 of 2007, which was under challenge in LPA.
My lord, this that we have not brought, my lord, but this order is very clear. So far, the action taken by the state to get it amalgamated with the other cooperative banks. My lord, if your lordship kindly permit, my lord, that is very clear. The learned counsel appearing for the appellant's original petitioner submitted that this later patent appeal has been preferred against the judgment and order delivered by the learned single judge in WPC number 4949 of 2007 dated 9 January 2009, against which the original petitioners had preferred this later patent appeal. Having heard the learned counsel for both sides and looking to the facts and circumstances of the case, it appears that the major grievances ventilated in memo of petition by the appellant's original petitioner no more remains in existence. The order of upgradation of Dhanbad Central Cooperative Bank Limited dated 3rd August 2007 as contained in memo number 1428 has now been withdrawn by the state Jharkhand.
That was an order of upgradation and
Yes,
not
yes.
amalgamation.
Upgradation. They said that
There is a
it will be-
difference between upgradation and amalgamation.
Yes, certainly. But this.
You see, the order says that the cause of action does not survive because that has been withdrawn. So it is not an adjudication on any law.
No, my lord, this.
We are adjudicating the law now for the first
Then
time.
this we want to show as a fact, that the state government wanted to have a control over the bank. And they succeeded, and ultimately due to the pendency of the matter before the High Court and the LPM, they video, they took back a step. And now thereafter they come with another step. So time and again
This time they have come up for
Another,
amalgamation.
yes.
That time they had come from for upgradation.
upgradation. And now they have come with the
There is a
amalgamation.
difference between the two. Both are not one and the same thing.
Well, of course. But the ultimate result, what was the result of upgradation? Upgradation, ultimate result was that the bank will be upgraded up to a state level, and you go, well, the persons of the present cooperative society will be upgraded, and they took the back a step.
Yes. We have seen this all. What else?
Then on the list of dates, Your Lordship, can you come back? This Reserve Bank has not granted approval to them. They gave a proposal on 6/6/2013. In the list of dates, my lord, at the bottom on page 2, it is the proposal of a Star Cooperative Society to Reserve Bank of India for amalgamation of the district Central Cooperative Bank with the Jharkhand State Cooperative Bank under the section 44 AK
So
of the
according to you, there is no sanction by RBI.
RBI,
I'll note
yes.
it down.
Madam.
RBI will have to respond to that.
Then
This has to come at what stage?
pardon.
This has, let us assume for a moment, if 39 is not applicable, matter ends.
Madam.
Right? If 39 is applicable, then at what stage this approval has to come? After the meeting or before the meeting?
No. Yes, this may be the question, my lord. This may be the another question. But so far section 44 AK is concerned, the prior approval is necessary.
Prior approval for amalgamation.
Amalgamation.
But
And
amalgamation-
then the question of decision of the cooperative members of the cooperative society will arise.
All right. That's all. There is no approval by RBI.
There is no. That they have already clarified. I have already placed one of their statement in paragraph 15 or 16 of the council, where they have explained that initially they have gave the approval, but subsequently when the facts were clarified, he gave approval only for the seven banks, including the Dhanbad Cooperative Society Bank.
What else? Non-approval by RBI, I have noted. This is the third point. What else? You just formulate the next point.
So far, Reserve Bank statement in paragraph 16, my lord, I just want to show to you.
They will respond. They have to show the approval.
Achha.
They will take care of that. Any other point?
Well, the point number 4 is also on about the validity of Rule 39.
No, we are not on validity of Rule 39. We are on applicability of Rule 39. There is a difference between the two.
It is not applicable.
If it is not applicable, there is no question of its validity.
Yes.
It's not even under challenge in this case. That's all.
In case of any need, my lord, in reply.
In rejoinder you will have, but no fresh points in rejoinder. You exhaust all your points.
One more important fact, my lord, so far the approval is concerned. My lord, your lordship kindly for a moment, my lord, come to internal page 3 of short more release updates.
Yes.
And bottom of page 2, 6, item number 6. On 6/6/2013, the proposal of Registrar Cooperative Society given to the Reserve Bank for amalgamation of district central cooperative banks with the Jharkhand state cooperative banks under section 44 AK of the Act. And this is the annexure B to the second supplementary counter affidavit
Okay.
filed by the state government. Then seven I am skipping, my lord, a list of dates. 8 your lordship can leave. On 10/9/2013, letter dated 10/9/2013 of the National Bank of Agriculture Rural Development (NABARD) addressed to the Reserve Bank. My lord, he is the main authority coordinating between the state government, cooperative society, bank, and the Reserve Bank. Letter dated 10/9/2013 of the National Bank for Agriculture and Rural Development addressed to the Reserve Bank of India regarding proposal of amalgamation of 8 CCB banks in Jharkhand with the Jharkhand State Cooperative Bank. This is dated 10/9/2013. Then 9, item number 9, on 11/9/2013, letter dated 11/10/2013 addressed to NABARD granting in principle approval to the proposal of the government of Jharkhand for amalgamation of the 8 district central cooperative banks in Jharkhand with the Jharkhand State Cooperative Bank. And the details we have already given. Then item number 10, 17/10/13, NABARD communicated to the Secretary, Cooperative Government of Jharkhand about in principle conditional approval granted by RBI, condition number A of the board, and general body resolution to be passed by all central cooperative banks and Jharkhand State Cooperative indicated their willingness to merge. So it was a conditional approval that if merger is allowed by the members of the cooperative society, then only the approval is granted. It was a conditional approval, not a blanket approval. Then, my lord, on 21/10/2013, this is annexure 1 to the writ application. A registrar cooperative directed Deputy Commissioner Dhanbad to call general body meeting and to get past the resolution for amalgamation of the Dhanbad district central cooperative bank with the Jharkhand State Cooperative Bank. And then 12, on 4/11/2013, the managing director of the Dhanbad Central Cooperative Bank called a general body meeting to be held on 24/11/2013 for taking decision for amalgamation of the Dhanbad Cooperative Bank with the Jharkhand State Cooperative Bank. This is annexure 2, we have stated. Then on next date, 24/11/2013, The meeting, general body meeting of the Dhanbad Central Cooperative Bank was held on 24/11/2013, and it rejected the proposal of amalgamation of the Dhanbad Central Cooperative Bank with the Jharkhand State Cooperative Bank. Well, this on 24/11/2013, Annexure E, this is Annexure E. Thereafter, a new proposal was given by the state government seeking permission of the RBI for amalgamation of 7 central cooperative banks in Jharkhand Cooperative Bank. Then on 18/11/2014, in partial modification to the earlier in principle approval dated 11/10/2013 accorded to the government of Jharkhand, the RBI communicated its in principle approval to the revised proposal of the government of Jharkhand for amalgamation of the 7 district central cooperative banks in Jharkhand other than Dhanbad Central Cooperative Bank with the Jharkhand State Cooperative Bank as per the proposal recommended inter alia received from NABARD. Then on 16 and then on 16, on 30th of March 2017, final approval to the proposal of the government of Jharkhand for amalgamation of the 7 district central cooperative banks, so and so with the Jharkhand Cooperative Bank. So this was all the 7 banks have been amalgamated. Then on 2/12/2013, serial number 17, the impugn annexure 3 has been issued. Which I have already placed to your lordship. Then item number 18, on 4/12, this is annexure 4. In compliance of the memo number so and so, Ranchi dated 2/12/13, and Secretary Managing Director of Dhanbad issued a notice to the PACs and Vyapar Mandals to convey a general body meeting. This was a direction, this we have also challenged, that since meeting on 20th of December 2013, the meeting was fixed on 20th of December 2013, and item number 19, on 20th of December 2013, annexure 3 and 4 to the writ application were challenged. An interim order was passed that until further order, no action shall not proceed, because respondents shall not proceed with any process of amalgamation. So this was the order passed. Then on 20th, in fact, the date of meeting was 20th of December 2013. The meeting was called, the next item number B, but there was lack of quorum. On 20th of December 2013, a stay was order was also passed by the High Court. A meeting was also held in which the quorum was not present, and it was adjourned for 9/1/2014. But thereafter, there has not been any meeting in the matter till yet. So these are the relevant facts which in case of any requirement, I am here to assist your lordship. In case if they find argue something else which requires any reply, then
Or the learned counsel for the parties. The learned counsel for the learned senior counsel for the petitioner has raised the following points during the course of argument. The learned counsel for the learned senior counsel, number 1, right? He submits that there has been no approval of cabinet to adopt 2-tier system from existing 3-tier system wide memo dated 8/10/2002, which is contained at, which has been filed along with the counter affidavit. He has referred to page 23 and 24, which has been annexed along with the counter affidavit. It was just a proposal, and final decision of the state government has not been brought on record. He has also submitted that it was for the respondents to bring on record the final approval of the state government, and has referred to section 106 of the Evidence Act. As such an approval is within the special knowledge of the respondent state. The Learned Counsel has also submitted that as per the rules of executive business, such decision was required to be notified. However, neither the rules of executive business has been placed during the course of hearing, nor any such provision has been placed. Point B. There was an earlier attempt for taking step for upgradation of the Dhanbad Central Cooperative Bank wide letter dated wide letter contained in memo number 1428 dated 3rd August 2007, and such step was withdrawn at the appellate stage. He has referred to order passed in LPA number 80 of 2009 dated 13th of July 2015. By referring to this order, the Learned Counsel has submitted that there has been repeated step taken by the state to disturb the peaceful and profitable functioning of Dhanbad Central Cooperative Bank. And one of such step was the order of upgradation. C. The condition precedent for amalgamation, that is the approval from Reserve Bank of India, has not been taken in the instant case, and accordingly the entire action of the state is vitiated. Number 4. Rule 39 of Jharkhand Cooperative Societies Rules 1959 is not applicable to cooperative banks, as the same is applicable only for the purposes of amalgamation of societies, cooperative societies,
Such as packs and
such as PACs and LAMPs. What is the full form of PACs? Primary
agriculture cooperative.
Primary Agriculture Cooperative Society, and LAMPs?
Larger area.
Larger area. Yes, on the last date also you were not able to give the full form, and today also
Larger
you are
area multiple credit cooperative society.
Larger area multiple credit
cooperative society.
LAMPs तो नहीं हो रहा उससे.
Multi-purpose society. Multi-purpose.
larger area multi-purpose society.
Multiple credit cooperatives.
Multiple credit.
Credit word is there in both. Max will.
Mul- Give us the full form, please.
I'll give it in writing.
You give it in writing. Right, I have to incorporate in this order.
Yes.
Okay, that is all.
One more fact.
Yes.
Your Lordship, can we see the counter affidavit? Counter affidavit, page 35, where another order of this honorable court has been enclosed, where in relation to this very bank. That is page 35, counter affidavit of respondent number.
Managing committee.
Respondent number oh,
25/3/2021.
25/3.
LPA number 68 of 2020.
Page number, please.
Page 35
Page 35 of the counter affidavit.
of the managing committee.
Managing committee, my lord, filed on 25/3/2021.
25/3/21. Yes, page number
Page number
35.
35.
30.
Order dated 19th June 2018. Very first paragraph, it is in relation to this very bank. The government cannot run the cooperative society even in the name of administrator.
I don't know. From where do I get it is in relation to the same bank?
इसी बैंक के
Kesari
लिए।
is something else.
इसी में फिर इलेक्शन के लिए ऑर्डर हुआ, इलेक्शन हुआ।
No, I don't know which bank is it concerned with. How do I get from this order?
It appears that if you
Nothing has been mentioned. We do not know.
cooperative society, एक मिनट, a statement, इसका statement देखिए। See, paragraph 3 of the counter affidavit, internal page 4 of that affidavit. That the Dhanbad Central Cooperative Bank remains under supersession for no fault of the bank from the start of the year 2007 and remain under suppression for a period of 12 years and ultimately pursuant to an order passed by the Honorable High Court on 19th June 2018 in the LPA number LPA 68 of 2000 election of the
Naturally, that supersession was ultimately quashed because anybody cannot act as an administrator of a cooperative society.
What I want to show, my lord, that the very first line, my lord, of the court, where the court said the government cannot.
That is not a finding, please don't tell us.
What?
That is not a finding of a court. You see, the society was, the cooperative society stood, the banking society stood superseded and it was being run by some administrator. Therefore, this court observed that it cannot be run by government. Certainly, it cannot be run by government. There cannot be an ad hoc arrangement for an indefinite period of time. It has got no relevance.
एक तो इनका काउंटर के बारे में स्टेट के काउंटर, आई एम सॉरी मैडम, पेज 7 पर there they have
after I have dictated, I have given you more than 1.5 hours time. And after I have dictated all your submissions, now you want to argue again.
They have given threat, my lord, that we are only waiting till the stay order is continuing. That's why, my lord, we want
Please
to
go and file FIR if they are threatening.
and only the decision which we want to give to your lordship, my lord, that
Yes,
even in the case
if
of
that is so, go and file FIR, please.
even in case of threat, my lord,
Threat is a very serious word.
my lord, for taking over control, my lord, okay, that's why, my lord, the writ is, my lord, these are the two judgments, my lord, rely, my lord, so far the threats and the continuation of it.
Threats.
The writ is maintainable so far even in the case of any threat. The court has said that there can
But
be
there is no allegation of threat.
इन पर ये पैराग्राफ 26, 27, 28 काउंटर में बोले हैं
That they are threatening you.
that we are not acting only because of the stay order passed by the court. This much they have said.
No, naturally, because of stay order, they are bound not to act. They are abiding by the law of the land.
No, but what we mean to say, that they say that since they are not
If a person says that I will abide by the order of the court, so that is not a threat.
but we say only because.
And one more thing, that this is, the petitioner is Tundi Primary Agriculture Society, it's a PAC, right?
Yes.
And you have challenged the decision of
Being the member of the Dhanbad Central Cooperative.
and Dhanbad Central Cooperative Society by itself has not challenged this order.
I am here to subscribe, only 2 minutes time I will take.
No, it is 1:45 already.
No, I will give the law challenge from the.
You might take 2 minutes, I may take 2 hours. I'm a slow judge, very slow in going through the provisions of law. I can't be as fast as you are. I will continue hearing tomorrow.
Understand that tax is not being paid today. I thought my lawsuit is reserving.
No, I'm not reserving. I will hear you because you see, we have to ensure that the petitioners complete their arguments in all respect. I would also like to see whether they have taken any plea regarding cabinet approval about all these things, or they are just arguing out of the blue. Because that is something, whether when there is no cabinet approval, when there is no these compliances, at least they have to plead. I do not know.
The burden of proof.
Yes, then the burden of proof will come. So these things I will check, and you also address on that. As the court time is over, the arguments of the petitioner is complete. As the court time is over,
5 minutes only.
I will give you 5 minutes more, but I will conclude your argument today.
Well, two things. The first you said, Lordship said the pleading. Certainly, I don't.
No, it is not a rejoinder. I just ask them, they will have to respond to it. So we have to go by the plea. I am very, you see, you have seen me for so many years. I am very strict about the records. Any argument beyond the records, I do not enter.
What I say, so far the approval is concerned, what I say, that should be my words, that it is an extra document which on they say it is a proposal.
Kindly, you see, please do not, you have argued your point, I have noted your point, right? We will see what is to be done to that. If whatever they say, you will have a time to rejoin so far as that point is concerned, but not
It
as
is
this.
for them to show whether there is approval or not, cabinet approval or not.
By virtue of that very decision, a number of banks have already been amalgamated, I think.
All
Right?
were in law.
7 have already been amalgamated by virtue of the same decision which they are questioning.
On exercise of 44A.
No, whatever it is.
Yes,
But
not
by
on
virtue of
exercise
the same decision, the other banks have been
Not on
amalgamated.
basis of same. On basis of the first decision, under exercise of power under section 44AK.
2002 decision.
Yes, 2000.
On the basis of the resolution, on the basis of same resolution.
But the resolutions
Okay.
have been brought before the court. That they
Post
have
this
not
case for
brought.
further hearing tomorrow at what time?
Tomorrow? Saturday.
Saturday working.
It's a holiday for you, it's not a holiday for
No,
me.
हम कहाँ कर Saturday working है.
हम लोग का बहुत केस लगा हुआ है कल रिटायर्ड बहुत केस लगा हुआ है काइंडली कंसीडर बहुत सारा केस लगा हुआ है रिटायर्ड
Okay, on Monday?
ट्यूसडे रख दिया है
It's not your choice like
No,
this.
no.
You see, we are hearing it, we will hear it day to day for special reasons. You come on Monday. It can't be like this. You see, in the midst of the matter, I will not keep on adjourning matters like this. Once we have opened the file, we will conclude.
This much of competition is enough.
On Monday, Monday को second half में क्या है? We will take up the matter at 12 o'clock. You initially finish your work, and if we do not finish it by 1:30, we will continue in the second half also.
सेकंड हाफ नहीं हमको थोड़ा जाना है बाहर थोड़ा हम आएंगे
अभी तो इन लोगों को बहस करते करते सेकंड हाफ. Okay, at 2:50. 2:50. Fine.
Monday 2:50.
Monday 2:50. It is already parted, I suppose.
I'm sorry, my
Yes,
lord.
लेकिन वो last order हमको नहीं
I
दिखा.
apologize, my lord, and very thankful for the
अपलोडेड है, मेरे पास नहीं है रिकॉर्ड पर, लगाया नहीं है आपने.